addition to the litigants and their representatives, we have some other people that are presently in court, and I would like you to indicate your appearances on the record right now. Mr. Langley, you want to start out?
Yes, Your Honor. Graham Langley, Milwaukee City Attorney.
Record should also reflect that the court has had a telephone conversation with Attorney Ken Murray. You want to indicate what... Well, first of all, I think Mr. Langley wants to indicate what he's done at this point as far as the records that he's reviewed.
Your Honor, for the record, if the court will recall, on Monday evening, we produced the entire internal investigation relating to the discipline of 2 police officers who were at the scene of the incident involving Mr. Symphones and Jeffrey Dahmer. We produced that information pursuant to an order of the court. At that time, I indicated to the court that we would look through the entire internal investigation to determine if there was anything in that investigation which might assist the defense in the issues of this case. And specifically, I'm referring to observations or statements that witnesses or police officers may have made of Mr. Dahmer or his apartment or the scene of the Symphones incident or whatever that might in any way go to the issues before the court. We excluded from our review of the internal investigation anything that's contained in the criminal investigation and anything that's contained in the district attorney's in the Attorney General's investigation. We have now completed that review, and I should tell the court that I did a review of the file, and I also had 2 members of my staff independently do a review of the file. Assistant City Attorney Scott Thomas, who is in court with me, and another Assistant City Attorney. As a result of that review of the file, we have come up with this packet of documents. I'm not sure that any of it is relevant to the issues before this court, but because of the possibility that it might be, we decided that this was the packet of documentation that we would produce. Now the question becomes, how do we proceed from here? Obviously, we desire, to the extent possible, to avoid any problems with the due process rights of the police officers involved, that the information remain confidential unless it is necessary to be used in this trial.
The suggestion I made, and I think that it's acceptable to Mr. Murray with certain provisos, is this, that over the weekend, copies of this information would be made available to Mr. Murray and Mr. Guerin so that they can review it. It would be the intent of the court, if there is no objection, to then make those materials available to Mr. Boyle under a protective order of the court, which prohibits him from making any disclosure of those materials without prior approval of the court. He would then report back to the court as to what materials, if any, he would like to use. Counsel will then be given an opportunity to make objections to that information being made available to Mr. Boyle. Now, that's what would happen so long as there are no objections that are raised by Monday morning. If there's objections raised by Monday morning, then this court will set a time later that day for counsel to have the opportunity to appear and be heard. Now, Mr. Guerin, you're nodding your head that you seem to be, that's acceptable to you, is that correct?
That's my understanding, I have no objection.
Okay. Mr. Murray has indicated he has no problem with that. Mr. Boyle?
I understand I'm going to receive a packet of material. I was thinking of something else for the court.
At the moment, you won't receive anything.
Oh, okay.
If this is acceptable, and see, the point is this, that they're not aware of the packet of materials we're talking about yet.
Oh, I see.
They only heard about this a matter of a few hours ago.
Okay.
And Mr. Murray has asked for, and I think Mr. Guerin probably joins in the request, that he should have the weekend to review the materials to see what we're talking about.
Well,
but then if everything is in place and they have no objections, then the packet would be made available to you under the protective order.
That's great. That's small enough, we can read that in no time.
And if there is a problem, we'll argue about it on Monday.
Fine,
Okay?
thanks.
Okay,
Your Honor, we should turn over 2 packets to the court.
okay. Okay, Vicki, those materials should be secured, so. Okay, that I think covers this problem, at least until Monday morning.
Thank you, Your Honor.
Okay, thank you. Now, counsel, you indicated to me there were some legal issues that you wanted to raise at this time concerning a witness.
Well, I think I should start because I'm about to proffer a witness. And for some reason or another, it appears as though we're going to have this discussion ab initio outside the presence of the jury. I think I would have a right, if I chose to do it the other way, of calling the witness and forcing the district attorney to object after a question's asked, and then we could have it. But I don't know why I have to play those silly games. I think it's important that I iron out the matter concerning the calling of the next witness, and therefore, I would tell the court that I am prepared. By the way, do you want to tell us, for the record, who's at council table with you, please?
Please, the court. With me at council table is, of course, Lieutenant Kenneth Moyler of the Milwaukee Police Department. And to my left, joining at my request, is Dr. Ellen Stury of the University of Wisconsin at Milwaukee faculty.
I'm about to call a gentleman by the name of Robert K. Ressler, R-E-S-S-L-E-R. He is director of the Forensic Behavioral Services that is located in Spotsylvania, Virginia, S-P-O-T-S-Y-L-V-A-N-I-A. Mr. Ressler still may be called as a witness, but primarily he would be called to render testimony relative to 3 things. 1, laying a foundation for certain psychiatric and psychological witnesses that I would be calling. 2, answering, if otherwise qualified as an expert, a hypothetical question. And 3, rendering expert opinion on the basis of what he feels relative to the conduct of Jeffrey Dahmer. Mr. Ressler has a Master of Science from Michigan State University. He was in the United States Army from '57 even up till the present, when he is retiring as a reserve full colonel. 1970, he was with the Federal Bureau of Investigation and remained with them until 1990. From 1970 to 1974, he was a special agent with the Federal Bureau of Investigation. 1974 through 1990, he became an instructor in the Behavioral Science Unit of the Federal Bureau of Investigation. He was a special assignment was Criminal Personality Research Coordinator, which was done from the years 1978 to 1990. His professional and academic affiliations, he's on the faculty and was on the faculty of the FBI Academy, clinical assistant professor in the Department of Psychiatry, the School of Medicine at Georgetown University, and has been affiliated with other universities as an assistant professor. His professional organizations and membership, there's 13 in number, but the 3 main ones is he is a member of the American Academy of Psychiatry and the Law, American Academy of Forensic Scientists, the Academy of the Criminal Justice Sciences, the International Homicide Investigators Association. He was given an award as a non-psychiatric colleague to the American Academy of Psychiatry at the annual Jefferson Amicus Award for assisting that field of endeavor. His grants and research projects have been many, but the ones I choose to make the court aware of at this time are the Criminal Personality Research Project of the FBI and Sexual Homicide Crime Scene Data. He has specialized training, amongst his training, criminal profiling and crime scene analysis, all of which he did and learned of while he was a member of the Federal Bureau of Investigation, and he taught the same at the FBI Academy. He has written a series of books, one called Sexual Homicide Patterns and Motives, He has written a number of, he's currently writing another book. He has published in the American Journal of Psychiatry, the FBI Law Enforcement Bulletin, the Journal of Interpersonal Violence. His articles primarily regarding criminal profiling in sexual and/or homicidal crimes include sex-related murder and crime scene investigation, serial murder and new phenomenon of homicide, the presumptive role of fantasy in serial homicide, sexual homicide, a motivational model, offender profiles, a multidisciplinary approach. He has made numerous, 300 as a matter of fact, professional presentations in this area of endeavor. His presentations have been given to organizations such as the American Psychiatric Association, American Academy of Psychiatry and Law, many police departments, American Academy of Forensic Scientists, American Psychological Association, and the FBI National Academy Association. The typical names of conferences where he's made these presentations are psychological profiling of unusual homicides, profiling of multiple murders, mass murders, and serial murders. I would like to indicate to the court that there came a time in the late 1970s and into the 80s where the FBI, in trying to help local law enforcement, went, when called upon by local law enforcement, to assist them in trying to determine the type of person they were looking for in unsolved homicides and unsolved serial murder cases. The FBI, and Mr. Ressler primarily, as the director of the project, went about the business of finding out whether or not there were any common threads between people who were known serial murderers and whose information was known on a professional and scientific basis, and those who had been apprehended and in personal interviews with the likes of John Gacy, the Hillside Strangler, people of that sort, in order to see whether or not they could create some understanding to tell local law enforcement as to the kind of person they should be looking for. Now, in preparing myself for this case, I came across, as anyone similarly situated, a lot of conflicting facts and information. And I, in the interest of trying to determine whether or not the conduct that I was made aware of, both from police reports, from Mr. Dahmer's confession, and from other information, plus interviews of Mr. Dahmer, whether or not I was dealing with somebody who was purely antisocial, which would be excluded by the instruction, as the court knows, somebody who was borderline psychopathic, somebody who was psychotic, somebody who was totally mentally ill that would be suffering from a psychotic disease such as schizophrenia. I learned in the course of that serial killers are a regiment unto themselves, that most serial killers are antisocial and they are not suffering from mental disease, at least as far as the research was concerned. What Mr. Ressler has done while he was with the FBI, and as he would be prepared to testify to today, is based upon crime scene investigation, the confession of Mr. Dahmer, the information given to him through discovery from the Milwaukee County District Attorney's Office, that Mr. Dahmer fits a certain type of profile. In other words, if Mr. Dahmer was not, if all things known about Mr. Dahmer were known right now except his identity, then it would be a Mr. Ressler who might be able to advise the Milwaukee Police Department or the West Dallas Police Department as to the type of perpetrator they might be looking for. What has come about this analysis that is at least 12 or 13 years in duration and is used by psychiatrists and psychologists, it's available to them, they're aware of it, they use the same kind of language representing the concepts as Mr. Ressler would testify, is that people fall into three categories. They're either organized killers, disorganized, or mixed. That they have some organized aspects to them and some disorganized aspects to them. That this concept that the FBI has used and that Mr. Ressler has used as a law enforcement officer, in effect yields the following information. That the organized person is not one who is suffering from a mental illness. that is an antisocial person. And the reason for that is because of the commonality of a number of things that are more antisocial in nature. As an example, the antisocial serial killer never admits to his serial killings, basically until the last moment, if at all. There's always a total denial. That puts him in from a classification that the FBI says that's, and Mr. Ressler, when he's a member of the FBI, said that's a category. There's a whole bunch of things that they use to show what you might be looking for in a profile. The reason Mr. Ressler becomes important to my case is that he would testify, if allowed to render an expert opinion, that Mr. Dahmer has evidence of both organized and disorganized traits. That his organized traits are A through L, and his disorganized traits are M through Z. And as a result of that, it is his opinion, based upon his many years of experience in the field of crime scene analysis, that Mr. Dahmer tends to be in the more disorganized category than he is in the organized category. That is a foundation question to allow the doctors to utilize this information to bring to the attention of the jury that they believe that the conduct of Mr. Dahmer was into the psychosis mode rather than the antisocial mode, and all of my doctors are going to testify to that. Dr. Becker, when I talked to her, and I didn't, of course, cross-examine her on what she meant, but she clearly talked about this concept with me, and I gleaned from her that she is talking about the same kinds of things. But here I have a person whose 20 years of his life was devoted to law enforcement, who I came to and gave information to and asked him to analyze it and to give me some idea based upon his knowledge of experience and training, whether or not he could be of any assistance to me in bringing facts to the attention of this jury that may help them resolve the question before the court. Now, we all know what the rules of law are relative to the introduction of expert testimony. And there's a great liberal bent in this state that we really bend over backwards if the expert can help in any way to bring to the attention of the jury facts they would not otherwise know from another source to assist them in their decision. It's the matter of weight, then, that they can accept or reject, which covers the situation and gives to the court the discretion to lean more towards allowing expert witnesses to come in than not. Secondly, I would like to bring to the court's attention that in the material, and I think it's in the State versus Carlson case, that's 5 Wisconsin 2nd, the court says in page 606, even under the right-wrong test, they're talking about the right-wrong test, but they said that the rule in this state, and it's also quoted in a jury instruction on the materials that you're going to be using as a footnote, no evidence should be excluded which reasonably tends to show the mental condition of the defendant at the time of the offense. I could cite to 4 or 5 other cases that the court might want to look at if the court feels that there's a specific question. I don't think there's any question that he qualifies as an expert. I think the state has a right to say whatever they want to say concerning his opinion. However, when Mr. McCann made his opening statement, I had heard him say a number of times that this man, Jeffrey Dahmer, when he was doing these things, was in control. It was control, control, control. I submit to you, Your Honor, that what appears to be control to the layman will not necessarily be control as it is to someone who has been studying the profile characteristics of a batch of serial killers, when we know that the database of serial killers, thanks be to God, is not all that large, that people, when they're considering whether or not Jeffrey Dahmer, while he was going about the business of his serial killing, was really a disorganized killer, a mixed killer, or a organized killer, so that the doctors, when they testify as to their opinions, might also allow this jury to understand what a man like Mr. Ressler says these kinds of things may mean on the basis of his 12 years of experience studying this very, very small measure of humankind that has been come to known as serial killers. So I also would like to tell the court, and I have some material here that he has written in his book that deals with the concept of organized, disorganized, that I can give to the court if the court would like to see it before it makes a ruling. But I would also like to tell the court that there is an article that is written by a doctor by the name of Resnick, a co-authored Dr. Resnick. Dr. Resnick is, I'm sure I say this without any fear of any contradiction. As a matter of fact, Mr. McCann had considered, well, he put him down as a potential witness in one of the letters to us, but I don't know if he's going to be called or not. He is known to be one of the 2 or 3 nationwide experts in the field of necrophilia. In his articles on necrophilia and his analysis of necrophiliacs, it's called Sexual Attractions to Corpus, a Psychiatric Review of Necrophilia, the Bulletin of American Academy of Psychiatric Law, Volume 17, Number 2, 1989. The author, that is Dr. Roseman, R-O-S-M-A-N, and Dr. Resnick, R-E-S-N-I-C-K, state in a footnote, the authors thank D.R. Berg, D.S. Hucker, M. Marler, M-A-R-L-E-R, and the Behavioral Science Unit of the FBI for their assistance. I don't think there's any question whatsoever that I can call Mr. Ressler to the witness stand and render the testimony of the nature that I've just said. Thank you.
Mr. McCann?
I'm sure the court was waiting, as I waited, to see if counsel was to ever cite even one case where this man testified as an expert witness on an issue such as this. He cited no such situation, and I strongly suspect that this man has never been recognized as an expert to address the issue that he's going to try to undertake in this court. An issue that I believe firmly will confuse this jury with irrelevant testimony which will invade the province of the jury. When we ascertained what was the intent here by Mr. Boyle, I secured some materials that had been written by Mr. Ressler, a book, some other articles, and submitted them to Dr. Ellen Sturry of the University of Wisconsin Milwaukee faculty. She has a PhD in criminology, and she is very skillful in, particularly in statistics. And I submitted materials to her yesterday evening, and she very graciously on short notice has applied her time to those materials, and we consulted within the past hour on it. And as I had suspected, let me dwell a little longer on her because we're going to be detailing about experts. She has a PhD from the Criminal Justice School of Criminal Justice of the State University of New York in Albany, and her areas of concentration were in law and social control, criminology, research methods, and statistics. So research methods and statistics were one of her areas of expertise and concentration. Her dissertation topic was, quote, an empirical test of police personality typologies. And that involves statistics, and really what we're talking about in organized and disorganized subject is we're talking about typologies. She also has a master's in arts from the Criminal Justice of the School of Criminal Justice of the State University of New York, and her A.B. in 1973 is from in Forensic Studies and Political Science, a double major, College of Arts and Sciences of Indiana University at Bloomington. She is a skilled and respected in her field. She has a very extensive number of articles, and a number of them involve statistical studies. She advises me this vitae is dated by 2 years. Were her current vitae to be put in, there would be additional articles. I will have that marked by the clerk and ask that it be shown to Mr. Boyle and then submitted to the court while I continue my remarks. The expertise they're talking about is profiling, if it please the court. And the whole thrust of profiling is when you don't have the defendant in custody. which is a complete difference from what we have here. The idea of profiling is to assist the police by giving them some clues of who they're looking for, by studying crime scenes and saying, who do we want? Is it a young man or an old man? Is he a loner or what is he? And it's all looking to the future, all looking to an unknown. It's painted in broad parameters to assist police to say, who are we looking for in this type of an offense? And that's the whole idea of the typology. That's the whole idea of the research. That's the whole planning, is looking for an unknown. And that's what the thrust of the research is. Now we have a known person. These studies weren't designed to apply to understand known persons, and of the materials that have been published at least, there is no scientific study of applying this profile to people who have been arrested. No one that I know of has ever been allowed to testify on that, and certainly not to testify as a part of an insanity defense. I would be shocked. I talked to Mr. John Douglas of the FBI about this utilization. He is still there. I believe he is the director of that unit. And the idea of utilizing the profile to apply it to a person who has been arrested in an insanity proceeding startled him. And far as he told me, as far as he knows, it has not been done in the United States. And I listened with a keen ear to see if Mr. Boyle would say that this gentleman, Mr. Ressler, has ever testified in such a proceeding. And I submit to the court, I'd be very surprised if he did. I don't know of his ever having done it. Mr. Douglas could not conceive of it being done, and if it pleased the court, this is, if we were looking who has killed these 15 people, I would say bring in Mr. Ressler. Wouldn't be a court proceeding, maybe a John Doe, but I'd say, Mr. Ressler, come and sit down and let's talk about it. Who are we looking for? But that isn't what's at issue before this court. He will tell you, I'm sure Mr. Ressler will tell you, that the thrust and the purpose of those studies was looking for an unknown. That's what your profile is, an unknown. We have a known person here. And to rest then to ignore a mass of known information about this man and to turn to a profile that's designed for unknown persons is an absurd, absolutely, to take the word of Dr. Story, an absolute unscientific application of this material. It is a perverse, inapplicable profile, and if it please the court, this will confuse the jury, it will invade the province of the jury, and it has no scientific application to what we're doing here. And as far as I suspect, this man has never testified in an insanity proceeding attempting to use these profile statistics to tell a jury whether a person is sane or insane at the time he did it. A person in custody that's known, that can be studied and examined, who's opened himself and described what he did and so on. So if it please the court, I keenly respect the creative aspects of Mr. Boyle. It's creative, indeed, it's innovative. Indeed, under the Fry test, as far as I recollect, applicable in Wisconsin to expert ideas, this is as new as a babe that just sprung from the womb less than an hour ago. It is untested, it is without precedent, and it is an innovation sprung on the court which will confuse and mislead this jury. Profiling has no business in a courtroom where the person is ascertained. The whole purpose is apply it to an unknown. Here we have a known. And if it please the court, you can read all that research. I've read the articles. I've read Mr. Ressler's book. He doesn't speak in the book of applying this to determine whether a known arrested person is sane or not. If it please the court, let me point out also, we can't tell what is the database. Mr. Boyle says, fortunately, there are only few serial murderers. He attempts to gild what is a very ugly fact that the database is only 36 serial killers that they've studied. Further, we can't tell from looking at it whether it's 25 and you break out 11. Further, if it please the court, every one of the disorganized criminals in that study were heterosexual attacks. Not one of them involved a serial killer that was a homosexual. And if it please the court, I don't think Mr. Ressler is qualified to say that the same rules apply to a disorganized heterosexual attacker as applied to a homosexual, because as far as I can see, they never studied a homosexual serial attacker. Never. And the studies point out that all 12 of the disorganized were heterosexual attackers. If it pleased the court under the Frye test, this would be such an aberrant use of this testimony that it would discolor justice, frustrate, confuse the jury, and I ask the court, Dr. Sturry is prepared to testify. If Mr. Ressler wants to get on the stand and say, no, some of those 12 disorganized were homosexuals, I'll ask him, why didn't you put it in the study then? Why did you say that all 12 were heterosexual serial attackers? Dr. Sturry is prepared to testify. If Mr. Ressler wants to get on the stand, let's get to it. But if it please the court, in my opinion, this is really confusing testimony. Doesn't belong before a jury. It's unscientific. Creative. Mr. Boyle is a very creative lawyer, and I salute him for that. His attempt to say, fortunately, it's a small number. 36 is an infinitesimally small number to a database to start projecting and analyzing people on when you have the person in custody. Thank you.
I think I have to respond. First of all, I think the testimony would include John Wayne Gacy, who I think killed 35 young boys, so I don't think it is just a heterosexual kind of study. But I think counsel misses the point. First of all, this case is unique for the simple reason that there is no issue on guilt or innocence. So the only time it can be raised is in the insanity portion. The fact that it's innovative doesn't mean that it changes anything at all. The fact that Mr. Dahmer is known does not change a person who has the appropriate training of getting up and saying, based upon my observations of the crime scenes, the pictures, what I have learned, I can tell you that the person who committed these crimes would fit into this category, and the fact that the person is known doesn't take away the ability of an expert to tell this jury that many of the things that the state is going to use to show that Mr. Dahmer was a cool, calculating killer who was not suffering from mental disease are subject matters that the FBI, in the course of their training, look upon as things reflecting a person who is not necessarily merely cold, calculating, antisocial. Without rendering a psychiatric opinion, Mr. Ressler will be laying the foundation about many of the things that Mr. Dahmer did for the doctors then to tell the jury that when Mr. Dahmer led the officers back into his apartment with this poor youngster, Conrax, in the zone, that there was a dead body in the next room laying on the bed, and that he, Mr. Dahmer, was able to persuade the police that he had everything under control, that counsel for the state is going to be used as exemplifying somebody who's a very sane, calculating killer, when in truth and in fact those concepts by the FBI Behavioral Science Lab have been used not to demonstrate that kind of a person, but the opposite. And I think that I'm entitled to call my witnesses here unless I am overstepping the bounds of what is allowed to be testified into evidence by this court's discretion, not someone else's theory as to who can and can't be called, but this court, so that the weight of their testimony can be looked at by this jury to see whether it aids them in making decisions that when the state says A, that maybe it isn't A, it might be B. And I have a right to bring Mr. Ressler in here to talk about his analysis of some of these cool, calm, and collected things that Mr. Dahmer did, as not to being, as counsel for the state has made statements and opening statements, and he will in closing argument. And it's my opinion that the Frye test is no longer the test in Wisconsin, that the Wallstead test is the test in Wisconsin, and the court should overextend itself to allow someone who is otherwise qualified to render information to the jury that might help them in their deliberations on the questions before them. And I'd like to say this. First of all, Mr. Ressler has testified and has been qualified as an expert. He has not testified on this type of thing, because I don't know if it's ever been tried anywhere. I mean, we don't have a system where they've been
That's
rejected.
important to the court to know if it has been accepted in some other court.
I don't know if it's ever been tried before, Your Honor, because it's being tried for the first time, and because he has never been qualified as an expert on this question, may very well be that nobody has attempted to bring this kind of information before a jury on the question of a serial killer's organization, disorganizations, or mixed organization as being demonstrative of the state of mind of that serial killer. But he can't be rejected, because if we've had 15 serial killers or 36 who have come to trial, and this hasn't been attempted before a courtroom, doesn't mean because he hasn't been qualified in others, or somebody else hasn't been qualified in others, he should be rejected out of hand. The court can't accept that argument. But I can tell you he has been accepted as an expert by courts in other jurisdictions on his expertise. I think 3 of them were in the sentencing aspect of it, and 1 in a sentence modification aspect. So I do think that this man has been found by a court to be a qualified expert. And I also would like to say, and I know Mr. McCann very well, and I know he is not attacking Mr. Ressler. I know that he is not saying anything negative about him as a person or a professional, and I want to make that clear. What he is saying is that he does not want a Mr. Ressler, who is now no longer a member of Mr. Douglas's FBI unit, to get into a courtroom and give his opinion as to how he would have told the Milwaukee law enforcement people what they should be looking for if they knew all of these facts but didn't know the perpetrator. And the fact that they know the perpetrator now doesn't mean that suddenly his thoughts and procedures that he would otherwise employ have no validity before a jury who's going to be asked to understand what do all these things Mr. Dahmer was doing all these times mean to them when they're weighing the question of Mr. Dahmer's sanity or insanity, as long as the doctors, when they testify, are able to say, these facts, Mr. McCann, as you're asking me about control, does not alter my opinion, because they are worthy of being considered differently than you are suggesting, and I am rejecting your basis for saying that these things don't go towards his mental illness. And that's basically what Mr. Ressler is doing, to tell from a law enforcement perspective that these facts of a person doing these things do not take on a certain mark to them, a certain imprint, that means that everything that person is doing then is more of an antisocial, non-psychotic, non-mentally diseased person. So I think the law is clear that the court has to bend over backwards. I think we've shown a basis. We certainly have shown a 20-year professional of the FBI, and he comes into this court to try and assist me in trying to do what I think is necessary so that the jury can make its decision. And if Mr. McCann wants to argue about the weight, let him argue about the weight. Thank you.
Just very briefly, the very heart of the matter is, and Mr. Boyle concedes that he has never testified before on such an issue. And if it pleases the court, this is not the time to start. On a sentencing, the court knows very well on sentencing issues, everyone, bring in anybody you want, bring in the minister, bring in the rabbi, bring in the priest, even the lady next door, the lady down the block, the bus driver, that always, anybody that wants to, any court, look, come on in, we'll hear their testimony. Totally different from a seriously contested issue of fact, as is the sanity in this case.
If I may just real fast, I wouldn't be calling him now anyway. I wanted to get this out. If you want to dwell on it, it's fine. I'm going to call Tracy Edwards, regardless of what the court rules, unless you're ready to rule. But I wouldn't be calling him even if you told me I could.
I think the court's prepared to rule on this. We might as well get it out of the way while it's fresh in everybody's mind. Section 907.02. If I don't cover up the microphone with the book, maybe it'll be a little easier for folks on the other side to hear what I'm saying. Section 907.02 is testimony by experts. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Now, in the Judicial Council's committee note, when this evidence code was adopted in 1974, there's some guidance along with quite a number of cases that are cited there. And it says that the test is whether such testimony will assist the trier of fact to understand the evidence or to determine a fact and issue. And goes on to say, with such a test, expert testimony will usually be admissible and will only be excluded if superfluous and a waste of time. And I guess that's what the court has to determine here. What my understanding is, what we're taking a science, and maybe that's too strong a word, but a procedure that's been developed in law enforcement, where you take information as to crimes that are committed, you put that together and you try to develop from that a profile for the person that you're looking for. Now that's how this information got developed, as I understand it. What the defense would like to do is reverse the process. That we have a defendant, a known person, and that he's committed some crimes, and from that infer what his mental status was at the time he committed the crimes. Will that be helpful to the jury? I think in evaluating, first of all, I have nothing to indicate that that reverse procedure is helpful. One. Two, this defendant has been examined by I don't know how many psychiatrists and psychologists who have rendered opinions, some of which agree and some of which disagree. But it would seem to me that the opinion based upon an examination of this defendant just so far outweighs the value of a profile theory that indeed that testimony would be superfluous and a waste of time, and on that basis the court will grant the state's motion to exclude the testimony.
In the interest of making my record,
Yes, you may proceed.
I would like to tell the court that I am not going to, nor would I ask Mr. Ressler to render an expert opinion on the mental condition of Mr. Dahmer. I was reversing the procedure so that Mr. Ressler, because of his expertise, would be able to render an opinion as to whether certain conduct by a person who did certain things was of an organized, disorganized, or mixed category as a foundation for my doctor's testimony. And last but not least, in spite of what the court has ruled, I think, and I'm going to ask the court, if I can call Mr. Ressler and ask him a hypothetical question based upon his knowledge and experience. If a serial killer did A, B, C through L, X, Y, and Z, would that be indicative that that serial killer's conduct was considered that which the FBI has developed as a useful tool in law enforcement as being indicative of an organized, disorganized, or mixed person? And I submit, taking into account all of what the court has said, the court still has to address my desire to put Mr. Ressler on as a hypothetical expert, to ask him questions that are now into this record as to how someone in the FBI behavioral science would categorize the conduct of a human being who admittedly did A through X. And I would ask that the court also rule on that question, because I think that's a viable way of my being able to bring this issue to the attention of the jury and get around the objections that the court has just addressed itself to in accordance with the decision that he has rendered.
Mr. McCann?
I object to him being in front of a jury, presenting something like that in front of a jury. It's between the counsel and the court how he chooses to make a record and what the court chooses to permit him to make a record, but not in front of the jury.
I think the defense has the right to make an offer of proof in whatever form it chooses to do so. And if, having heard that offer of proof, if I think that there are some things that properly the jury should hear, I can make that ruling.
I'd like to do that, and I'd like to do that, though, after we start up and I bring Mr. Edwards up, so I can properly formulate the offer.
Sure.
I have Dr. Sturry here, though, for that specific purpose, to counsel me in that event. And when do you have in mind doing it?
About an hour from now. Is that a problem?
Dr. Sturry can wait. Now, I take it this is going to be done in the absence of the jury.
Well, I think I'll offer.
No, it would be in the form of an offer of proof, which necessarily must be outside the presence of the jury.
Right.